Oh, we've been talking, David. People have been sending in their questions, and we've got actually quite a few waiting for us. So thank you for those who've already submitted those. We'll try and pick some that will show a variety of the questions that have been asked, and try to give you as many answers as we possibly can. Let's have a look what we've got in our pots, David.
Just go.
Let's take this question, which says, what is the SRA doing to assist the firms who are in the ARP? There seems to be very little help, is the question. So it's been very topical, David, the ARP, and we know that we've been doing quite a lot of work in the SRA to look at those firms that are in the ARP and understanding why they're there. Specifically, what are we doing to assist them?
Well, Sakitra, I know that in one or two cases, I perhaps can't speak for more than that, there has been a trialling of a form of relationship management. Colleagues have gone into firms in the ARP and tried to understand the risks those firms are facing and tried to assess the options available. Unfortunately, firms that have perhaps been in the ARP for well, a month or two ago, coming up to 2 years, had obviously had a lot of time to try to bring their situation under control, to find commercial insurance, and in some cases there were not too many options available. But there were several cases in which firms were able, with some guidance and assistance from the SRA, either to successfully merge with other businesses or in one or two cases to obtain commercial insurance and remove themselves. So it's not all a black picture, and we learnt a lot from the process this year, but there are still things to get to do better and to get right, but we were pleased with, in general, with how that went.
And just picking up on what you said, David, the other thought that has just come to my mind is that actually, if firms are having difficulties, this is the time to come to us and talk to us and be proactive in saying what those issues are within the firms, so that you can get that help earlier. I'm not saying that we will always have the answer, but we can certainly be in a better position to assist you if you can engage with us earlier. So we hope that helps answer that question. We have another question lined up there, David. Will the SRA prepare and circulate model risk registers? And this is something we have debated quite a lot.
Yes, I think my view to start with is that we're very pleased to talk to people about different types of register that we've seen. We're a little bit wary to start with about giving a precedent and setting a model, because we really want firms to find out what works best for them, to make the journey of looking at their risks and recording them in a way that is suitable for their practice. So we're not averse to giving a bit of a help, but I don't think, personally speaking, I'd like to set an absolute precedent.
I think you're absolutely right, David, and that goes also in line with our view of outcome-focused regulation, that in fact the firm has to do that assessment in a way that best suits them to identify their own risks, and we don't want to be prescriptive about how that is done, but would be willing to interact with firms to understand where it could be improved if that was at all possible. And we hope that that has answered that question for you.
I'm looking at a question now which says, how do you identify a high-risk firm? Well, I think we were trying to give a little bit of a steer to that in the presentation, and it comes about in various ways. I think that the main driver is going to start with to be an analysis by our risk centre of a particular firm type. That is a bit of a generality, but within having used that as a starting point, we will look at a firm and see whether we have records of high levels of complaints or problems, and that will adjust our assessment of a firm. There may be positive factors that move our assessment in a different direction. It's difficult to be more precise about this at the moment because part of the pilot is to work out how the risk assessment and processing goes. So it will start out as being fairly general, but move to be a more sophisticated and targeted assessment.
I think that's absolutely right, David. Thank you for taking the time to answer that one. While you've been busy answering that question, I've been busy scrolling through the many questions that are coming through, which is fantastic. And I have a really interesting question here, which is, we went to a risk management training course recently, and we're told that the SRA can be extremely aggressive when they visit a practice, finding fault with almost everything. How will relationship management differ from what exists at the moment? It's a very interesting question, and I'd like to take that if I may, David. I'm sorry to hear that somebody was saying that the SRA can be extremely aggressive, and perhaps there are times when that's necessary, for example, where there's a risk of client money being taken. But I don't think that is common practice within the SRA. In many other visits, for example, PSU visits tend not to have that flavour. Perhaps they have in the past, but my experience has not been that. How will relationship management differ from that? That's an excellent question, because what we are saying with outcome-focused regulation, with principle-based regulation, is that we need to have an adult-to-adult relationship with firms. We need to be able to trust you to undertake your role within the firm and to comply with your regulatory requirements in a grown-up way. And if you are able to do that and demonstrate that you are doing that, we should be able to leave you to carry on to do that and focus our resources on those firms that are actually the riskiest. So to test that in relationship management specifically, we are asking firms to bring this information to the table and working with them to understand what those issues might be. And rather than pointing fingers and telling them off for being aggressive, we are going to work with them to say, actually, we don't quite understand how you've come to this conclusion, and be challenging where required, but not necessarily aggressive. It also links to our enforcement strategy, which we published with our April consultation paper, which sets out that how we will work with firms who are willing to work and get things right, and how we will work with those firms who are perhaps less willing to work with us to put things right. So the enforcement strategy does also set out how we want to approach issues, and I hope that you'll see a significant difference in how relationship management works.
Without wanting to just focus on this question, can I add something from a slightly different angle? We have already had one or two firms come to us with particular issues. They're not in the pilot. We've had 2 or 3 self-reports. We've had a firm who's come to us to discuss a particular topic which is an emerging issue. And in those, particularly with the self-reports, we have been able to be very focused. We have gained confidence that the firm is dealing with the particular problems in a very reasonable way, and therefore there's no question of being aggressive. We've seen a sense of cooperation and to sort the problem out. So I share Sakitra's view that it's very unfortunate that aggressiveness has come to the fore in the past, and we want to move away from that. I spotted a couple of questions that I'd just like to pick up on. How many firms are being supervised under the pilot, and is it too late to join the pilot scheme? The plan is at the moment to have 18 to 20 firms. We may have covered that off in the presentation. We've already got 6 up and running, another 6 or 7 shortly to be announced. There have already been 50 firms or perhaps slightly more who've expressed an interest. We are doing our best to find ways of working with firms who want to have some relationship with us, but not everybody can be in the pilot. Is it too late to apply? No. There are still going to be 4, 5, 6 slots left for the pilot, at least in the forthcoming week. So if you're interested and feel that you have a firm or a practice that may be of interest to us, please get in touch.
Thank you, David. There's another question that's come in about documenting and registers, and I'm assuming this is from a sole practitioner, because the question says, what is the advantage of documenting these matters for a one-man firm? And that's a very good question, because there may not be any real benefit, because the one person in the firm who needs to know it does know it. And we're not being prescriptive by saying that you need to have documents or registers written up, but it may help from a continuation point if you need to be away for any period of time. Is there somebody who needs to step in for you, who needs to pick up things? Perhaps there are some advantages of having some key things recorded, perhaps in cases of your absence.
I think that's right, Skeetra. I'd like to add another point. I was went to one of the first pilot firms on Friday, a firm that has been using risk registers for, I think, certainly 8 years, if not 10. And there was a great deal of use to be able to look back over the registers that had been produced over that time, because it was showed how particular risks had been identified and managed and successfully mitigated from a serious or high impact level to a lower way. OFR is all about the ability to demonstrate that certain outcomes have been achieved, and I think moving that to risk registers would mean that even a one-man firm can, if we turned up, could say, look, this is what we've done with the risks and this is how we've moved on. I think we may have possibly one or two people waiting for oral questions. Can you tell us if that's the case, Steve?
Okay, if you wish to submit a question via the phone, you can press star 1 on your telephone keypad and wait for your name to be announced. At this time, there are no phone questions. However, please stand by.